All right, I don't know if the marshal's office or anything's going to make an announcement here, so I'm just going to go ahead say that the court for the Sixth Judicial Circuit is now in order. Where the Sixth District Court of Appeal is yeah, okay, he's muted. All right, we're in court today. I'm Judge John Stargell. I'll be presiding today. We have Judge Mary Alice Nardella, also a judge of the Sixth District Court of Appeal, joining us, and then Brian Lambert, an associate judge, who's on the Fifth District Court of Appeal, but who is assisting us in the case today. This is Thursday, July 11th, and this virtual session is a little bit different than in live court. We have a virtual timer that someone in our marshal's office is keeping for us. We're joined today by counsel. For the one case that we have Maurice and Sylvia Ward versus Citibank et al. And I think we're joined today by Mr. Andrew Greenlee, correct, on behalf of the Wards?
Correct, Your Honor.
Okay. And Mr. Alec Hayes?
Yes, Your Honor. Good morning.
Okay. Since there is cross appeal on this, I'm going to ask both of you if you would like to reserve any of your time rebuttal. So, Mr. Greenlee, would you like to reserve any time?
I would, Your Honor. 4 minutes, if it pleases the court.
Okay, so noted. And Mr. Hayes?
2 minutes, Your Honor. Thank you.
2 minutes. Okay, then we will begin, and you will see in the box when your time is up. Just stop, and then you'll have whatever remaining time, regardless of what you asked for your rebuttal.
Okay. Your Honor, I'm sorry, but I don't see a timer on my screen. Should I be seeing the timer?
Do you also? Can you see it, Mr. Hayes?
I can, Your Honor. Yes.
All right. Perhaps if you look across the top, sometimes there's a little blue button that shows all the participants. The timer might be, yeah.
I got it. Sorry about that.
That's okay, and you can change your view as you need to. So you need a moment?
I'm ready to go, Your Honor. Thank you.
Okay. Well, the original appeal was brought by Maurice and Sylvia Ward, so I recognize Mr. Greenlee.
Good morning, Your Honors, and may it please the court. This case arises from a mortgage foreclosure action where the borrowers proved their defenses of unclean hands and equitable estoppel.
Well, can we start there? You talk about unclean hands and equitable estoppel being complete bars to foreclosure. Is there any authority for that?
Yes, there is. There is a United States Supreme Court case that talks about unclean hands closing the doors of equity. I would maybe approach it from the other way. I haven't seen a case where a party comes into a court of equity with unclean hands and has been able to prevail. The closest thing that we have cited in the papers by my friend on the other side is the Smith case, but they actually didn't prove their unclean hands defense because it was unrelated to the litigation.
Your unclean hands defense right now, as I understand it, having read the trial, was limited to the performance or the bank's failure to perform the forbearance agreement. Is that correct?
Not quite, Your Honor. There was also inequitable conduct. So after the bank or the lender breached the forbearance agreement, they also, instead of telling them, explaining it, they said, actually, we can't accept your payment because you're the subject of a foreclosure action, which wasn't true. And then Mr. Ward testified that they tricked him. They said, you have to go into foreclosure in order for us to give you a loan modification. And then they tricked him into accepting a loan modification that he really couldn't afford, and that added about $30,000 of principal to the loan.
Well, let me ask you then, if that were the case, the modification goes away, it goes back to the original mortgage and note, correct?
Well, we dispute that. Actually, if you look, the whole point of the forbearance agreement was to restore the parties to the status quo ante. And so our position is that Mr. Ward should be restored to the status quo ante. It would be profoundly inequitable to allow the bank to breach the forbearance agreement and then somehow come into a court and foreclose on his property when they didn't allow him to actually make the payments that he attempted to make. And again, this isn't just me saying that they breached the forbearance agreement. There are findings from the court that say that his payments were unreasonably rejected. And they say that there was, I mean, it's kind of euphemistic, but they say there were miscommunications. In our view, if you lie to the borrower and tell them that it's already the subject of the foreclosure proceeding, that's more than a miscommunication. That's just an outright lie with respect to your borrower. And we don't think, these courts are hallowed grounds. You shouldn't be able to come into a court of equity with unclean hands and prevail on the merits.
Let me ask you on that. Trial counsel said you can concoct a remedy that makes sense. That's what they asked the trial judge to do. And if you don't want to give us an outright win, then come up with an equitable solution. So the trial judge came up with what he thought was an equitable solution, which is they can foreclose, but they can't get the interest and they can't go out after a judgment for all of this accrued interest. And that was the equitable resolution. But then you all appeal.
Well, we
don't like that equitable resolution.
Well, we dispute that was an equitable resolution. Again, Mr. Ward, he didn't fight the case to shave off a little bit of interest here and there. He fought the case actually to save his house, the house that he built with his own hands. And when a lender comes into court and they haven't proven that they have clean hands, and in fact, the opposite is proven, then they shouldn't be allowed to prevail. The trial court, in fairness to the trial court, the judge attempted to do sort of a rough justice and kind of split the baby. But again, these are affirmative defenses. It's a complete defense to foreclosure. There are many, many cases where the courts of appeal and the trial courts have prevented parties from undertaking a foreclosure where the party comes into court with unclean hands. And that's what we have today.
Counsel, what do we?
Go ahead.
No, go ahead, Judge Lambert.
Well, let me make sure I follow along. All right, so we have a mortgage. Your client doesn't pay, and they make a forbearance agreement, right?
Correct.
Okay, and then there's issues about whether there was compliance by the bank with the forbearance agreement. Eventually, though, the loan is modified, right?
That's correct. Yep.
Okay, so at that point, going forward, whether there was good or bad behavior, there is a modification agreement in place because your clients didn't pay weren't paying on the original mortgage. Am I incorrect about any of that so far?
Well, I wouldn't say you're incorrect, but it's kind of missing a little, bits and pieces here and there that we think are quite germane to the resolution. And one of the bits and pieces is that they, they breached the forbearance agreement, and that's a finding by the trial court. They said that they unreasonably rejected the payments because of, quote, miscommunications on the part of the lender. Namely, they lied to the borrower and said your house is already the subject of foreclosure proceedings, when in fact it wasn't the subject of foreclosure proceedings. Then Mr. Ward testified that they tricked him into entering into the loan modification agreement by telling him, hey, you have to go into foreclosure in order for us to give you a loan modification agreement.
Is that a trick, though? I guess I was reminiscing of my old days as a circuit judge in the world of foreclosure. We used to hear that all the time. It was contraindicated to me. It sounded stupid, but I hear lots of stupid things when I was a circuit judge. But that's when you're saying trick, that in fact was the protocol, at least back in 2008 and 2009 when the foreclosure crisis was going on. The banks would say you need to go in default before we can renegotiate. I know that's not quote our record here, but you're saying that's part of the trick of what they were doing. But that implies that they're actually tricking as opposed to that was the protocol.
Well, I don't know what the protocol was. I can't speak for the bank. Maybe my friend on the other side can give clarification for that. But look, I don't think that you need to be in default to get a loan modification. I've received a loan modification myself and have not gone into default. So I don't think it's
in any event. All right. So they modify the loan and
right.
And at some point there's a suit because they're not your clients allegedly are not paying under the modification agreement, right?
Right. That's correct.
Okay, and so why is that not dispositive? As to
Well,
that
what-
issue about the foreclosure, I mean, forget about the attorney fee thing, and we'll talk about that later, but
Right. Well, I think it's not dispositive because the trial court expressly found that they carried their affirmative defenses of unclean hands and equitable estoppel. So that's actually what should be dispositive, is the findings of the trial court, which, by the way, Your Honor, have not been appealed. Even though there was a cross appeal made, there was no challenge to those findings. This court is a court of review, not first view.
No, counsel, I see your point that they haven't challenged the trial court's findings that unclean hands and equitable estoppel doesn't allow the trial court to set aside the loan modification. I see that point. But when we're also looking at the loan modification, didn't you guys waive all of those defenses when you entered into it, to Judge Lambert's point? Not only under the law of novation, but you expressly waived them in paragraph 5.
Your Honor, it's our position that loan modification was secured through trickery, through miscommunication. Again, the trial court expressly found that there was miscommunication, and it's not for nothing that the trial court actually set the loan modification aside. So it would be extremely odd for this court to say, well, notwithstanding what the trial court did, the loan modification is valid. The trial court set the loan modification aside, and that's a finding that hasn't been challenged on appeal. So again, it's quite illogical from our perspective. If the lender breaches the forbearance agreement, the trial court finds that the lender breaches the forbearance agreement, and the whole point of the forbearance agreement was to restore the parties to the status quo ante, or then the remedy to somehow be to allow the court to take this man's house. He did everything in his power to save the house, including trying to, look, he tried to save his house. Yes.
counsel, did Citibank sued on the mortgage modification? In other words, the mortgage was modified to the extent that the principal initially was 157 and something, and then was the suit for the principal of 186, which was the modified amount in the loan modification agreement?
That's correct, Your Honor.
All right. So in essence, the city was suing to enforce the modification because they wanted the principal amount. They didn't want 157. They said, no, you owe us 186 in principal because we all agreed to modify it and you have breached the loan modification agreement awards. That was their position at trial.
That's correct.
And then the trial judge explained the reasoning, I guess, findings, reasoning, whatever. I know it's the oral pronouncement, it's not in the written judgment, that they find that there was your affirmative defenses to the loan modification agreement, which was the suit being brought, carried the day. And your position is, look, you can't go back to the original mortgage because the bank sued on the modified mortgage.
That's exactly.
Am I understanding your position?
That's exactly right, Your Honor. And I might just take it a step further because there's this. Well, first of all, it is quite illogical how the trial court explained its reasoning in the oral pronouncement. It said the lender has prevailed, or the lender has met its prima facie case, therefore it's prevailed. Well, that's not how it works. They meet their prima facie case, and then you deal with the affirmative defenses. And so at step 2 of that process, okay, they met their prima facie case. Then at step 2, if we prevail on our affirmative defenses, the case is over. And so that it's
if I understand, I mean, the law of affirmative defenses, for lack of a better, basically your position at trial is, even if we assume, Judge, that Citibank can prove we've defaulted on the loan modification agreement and that we owed 186 in principal, it's still, they should not get a judgment in their favor because we have affirmative defenses to that agreement that we've proved, and therefore judgment should be entered in our favor. No different. Analogizing, I drive negligently, I hit somebody, it's all my fault, I admit I'm at fault, but then I raise an affirmative defense of statute of limitations saying, yes, but you didn't sue me timely, I win because of the defense. The judge can't say, well, okay, yeah, that's true, affirmative defense, but I still gonna let you get some relief plaintiff because that's the fair thing to do.
Your Honor, I'm 100% in agreement with that logic.
I didn't follow the logic. I mean, I didn't follow the logic of the judge's findings. I mean, that being said, I'm not sure why your affirmative defenses prevailed, but as you point out, we're a court of review, not first review, so it's neither here nor there whether I'm scratching my head about what the judge said. But yeah, I'm. Go ahead. I don't take any more. Go ahead.
Yes, Your Honor. I'd like to again just kind of to put one final point on this. I think, Your Honor, I can't say it any better than Your Honor said it. That is our position.
Well, you
just
probably
articulated.
can, but you know, you probably want to.
Well, if I could say it better, it's probably what I said in the brief. So I tried my best. But Your Honor, one final point that I can't leave without saying, no matter what you all feel about our affirmative defenses and this split in between the loan modification agreement and you know, the underlying note and mortgage, we dispute that there is any split. The whole suit was brought on the loan modification. But setting that to the side, the attorney fees under binding precedent from this court cannot be sustained. And that's the CED capital case that's cited in our papers. They just had essentially a line item for legal costs, and the judge the judge didn't actually rubber stamp it. He did something quite odd. He said, well, I'm just going to cut this in half without any proof as to the reasonableness of the fees. And this court has been quite clear as to what it takes to prove up the reasonableness of attorney's fees. And I don't think there's any serious dispute.
What is the 60C? Where'd you go?
It's called, I don't know where I went. Can you hear me?
We can hear you.
Okay, here, I'm going to.
Tell me what the 6DCA says. I don't always read all their stuff.
Yes, Your Honor. I understand that you come from horse country and the 5th DCA. Your Honor, I will. Okay, so the 6th DCA, they say that there's two ways to prove attorney's fees. One is you can actually have the attorney who performed the tasks, and he can testify to his own personal experience in performing the task and to the rates that he charged. The other way is to introduce detailed business rules that have all the times listed out and the amount of time that it took to perform the task, timekeeper. And that way the court has that court and this court in its conducting review of any decision can say, yeah, you know what, that's reasonable, or no, that's not reasonable. What you can't do is have a line item that says attorney's fees, $50,000, and just stop there and carry your burden. That's not how it works under this court's precedent. If there are no other questions, I'll rest in reserve.
Okay, you have a little bit over 5 minutes.
Thank you.
Left. Mr. Hayes, you're recognized for your response and also for your cross petition.
Good morning, Your Honors. May it please the court. My name is Alec Hayes, and I appear on behalf of Citibank NA as trustee for CWABS Inc. Asset-Backed Certificate Series 2007 QS1. For the purposes of this discussion, I will refer to my client as appellee, Citibank, or lender. As Your Honors have pointed out, the 4 issues on this appeal are with respect to the unclean hands, the standing, the amounts due and owing, and conditions precedent. Our response in opposition to appellant's case in chief is that the trial court properly made factual findings that were supported by competent substantial evidence on the record, and the prima facie case of judicial foreclosure was supported by that evidence. However, it is our position that Citibank appeals I guess what we'll call it an arbitrary dilution of the final judgment amounts, as they were properly authenticated by business records submitted by Citibank.
Counsel,
Well,
I'm very
Go ahead, Molly. You win.
No, I'm very confused by the argument because I don't think anybody's arguing, well, outside of attorney's fees, this is a matter of evidence. It's an underlying logical reason that the trial court got rid of your interest that I don't see you ever attacking in your initial brief. And that's kind of what I think the panel was curious about earlier is why do they have these defenses, these equitable defenses when it comes to the loan modification agreement, when the loan modification agreement specifically says they release all of their defenses to enter into it. But you never make that argument.
At the trial court, the alleged date of default is post the entrance of the modification agreement, and when the trial court tossed and I guess, disregarded the modification. We, as Judge Stargel mentioned at the beginning, the trial court moved the it disregarded the modification, and we fell back to the original loan, the original note and mortgage.
Well, how does that happen? I mean, you modified the mortgage. I mean, you have a mortgage initially, and the parties then get together and saying, okay, we had that, but now we're going to enter into this new modified agreement and go forward from that. I mean, because clearly, I mean, I shouldn't use the word clearly. I should learn that after all these years. I mean, the modified mortgage was for a higher monthly payment. Certainly the wards couldn't say, well, we're just going to pay the $1,500 on the original mortgage, and that's fine because that's all we agreed to do. They agreed to pay a higher amount. And if they didn't pay that higher monthly amount, you would sue and say, you haven't been paying what the modified monthly amounts are. You are in default. We are accelerating. And you sue on the you sue on the new mortgage. I mean, the modified mortgage. Let's change that term. Okay, and so you proceed, and for the reasons as explained by the trial judge, the judge believes that the affirmative defenses asserted defeat the mortgage modification. I'm at a loss as to the theory as to why that means that you just put that aside and go back to the original mortgage, which is really not what the suit is about, is it?
No, Your Honor. It's as you mentioned, it's based on the larger capitalized amount that was effectuated.
Because you guys said you were 157 and you the wards got in default, so we're going to put that, we're going to add that onto the principal, and we got a new principal going forward, and that's actually what you guys won in the final judgment, the modified amount in the LMA. Right?
Correct, Your Honor. And that's the basis of our cross appeal, is the fact that the arbitrary award with respect to the amount, the final judgment amounts, don't exactly line up. It's based on a rationale that you just kind of highlighted.
But you agree with, I mean, they awarded you the amount of the principal. You're not quarreling with that.
Correct. Yes, Your Honor.
Right. You didn't like that you lost the interest and they cut your fees in half and things like that. And that's what you're unhappy about. For
precisely.
Generically, we can have more legal terms if you want, but that's what you're unhappy about today.
Precisely, Your Honor. Yes.
And before, that's why you appeal, cross appeal.
And then with respect to the Judge Nardella highlighted or asked opposing counsel whether there was any definitive authority with respect to whether the equitable defense of unclean hands completely wipes out the ability for a mortgage for a bank or a lender to foreclose, and there isn't in the state of Florida.
Well, no. I mean, this is not, it's not one and done here. I mean, certainly if you, let's say the trial judge found that you had not proved standing and you didn't appeal. That doesn't mean the wards get a free house. That just means you have to then allege a different default on a different thing. So, but as to this case, if I'm trying to piece together what the trial judge did, there's a loan modification agreement that you're suing on, and the trial judge finds the affirmative defenses to that are valid and persuasive. Isn't an affirmative defense basically says we agree with what the complaint alleged, but we have a defense that overrides that, and therefore we as a defendant prevail. Isn't that the whole theory of affirmative defenses, of which you have not challenged, whether you should have challenged or not? You haven't challenged the validity of the trial court's finding that those affirmative defenses were proven. Isn't that the lay of the land here, for lack of a better appellate term here?
Yes, Your Honor, you're correct. However, we would argue that when the judge said that we prevailed on the case in chief and the prima facie case, in other words, the plaintiff prevailed on a significant issue of the litigation. And
that's what affirmative defense is. They're saying, yes, you prevail on that. You've proven, but that's what affirmative defense. You have proven that the defendant drove negligently and caused damages, but there's a statute of limitations that overrides that and defeats your ability to actually get a judgment giving you affirmative relief. Isn't that the essence of what affirmative defense is? And if that's so, the fact that the judge pronounces that you have in fact proven your prima facie mortgage foreclosure modification complaint is not the end of the story, is it?
No, Your Honor.
I mean, I know you
you're
don't like, I mean, and again, I may be with you on the theory of the affirmative defenses, but that's what the judge found, and that's not been appealed. And we're kind of stuck with that.
Correct,
That's
Your Honor.
binding upon it. That's what we say, stuck with that. Get a little,
Right, Your Honor. And
talking
you're
too much
correct.
common sense here. You got to watch out.
Yes. So, I'm not sure I followed the last question, but
I'm trying to figure out why you think you should still win when the judge says your loan modification complaint has been defeated by the affirmative defenses raised by the defendant, of which you have not challenged the findings made regarding the affirmative defenses from the evidence. If we are then, as we are a court of review and we don't go hunting or truffle pigging
Truffles.
like we use over here at the 50th, truffle pigging for issues here. At least a couple of my judges are truffle piggers, apparently. We don't go hunting for issues. We take the issues as presented to us by the briefing, which is the correct process of an appellate review. If we're bound by that and that's not been challenged, how does that not become dispositive of the appeal?
because, Your Honor, we would argue that the original loan and the original promissory note, with the exception of the increased monthly payments and the capitalized interest on top, the terms of the agreement and the spirit of the agreement remain completely unchanged.
Well, okay, but you modify. Yeah, okay. You didn't redo all the boilerplate language. You had a mortgage. You say we are going to modify that. We're going to use a lot of the terms that we have, but we're modifying the principal balance, the payment terms, and we're going to go forward. And if somebody doesn't pay that, you're not suing on the old note. You're suing, saying, "Hey, you didn't pay your monthly payment of $1,931. You're not saying you didn't pay the $1,500." And so that's the theory. I'm at a loss as the theory that I'm suing because we have modified the loan and the mortgage. And now because the judge says, well, then that doesn't count. We go back to the old thing that we modified. I'm trying to figure out from the briefing why we do that.
Right, Your Honor. So as the trial judge stated that the modification was unenforceable, yet the original promissory note and the original mortgage, with the addition of the modification, were both attached to the complaint as well. So in theory, because the modification was disregarded, and because appellant's assertion of the affirmative defense of unclean hands, the trial court found was successful.
That's okay. Let me change your facts again. All right, so the mortgage is modified, and now the monthly payment in the loan modification is lower than the monthly payment in the original mortgage. And you can't go back and say, well, the trial judge, denied our relief on the loan modification, but you, Mr. and Mrs. Ward, did not pay the higher monthly payment on the original mortgage. You're in default on that, therefore bank wins. Does that make any legal sense?
It doesn't, Your Honor.
So you modified the agreement, and the judge did not enforce the modified agreement upon which you were bringing suit because of the affirmative defenses that the judge found right or wrong that have not been challenged. That's how I'm trying to get off.
Can I jump in here, Brian? Because I have a question too. So I'm sorry, Judge Lambert.
Go ahead.
So when they made the modification, my reading of the judge's equitable ruling, and I agree, it's kind of difficult to discern exactly what he was doing, but I think he was invited into this arena to concoct a remedy that made sense, and he tried to do that. But Mr. Hayes, I think what Judge Lambert and Judge Nardell and I are struggling with is, why didn't you all come back and argue in your briefing that the judge was wrong because all of the facts he was looking at were to the forbearance agreement, and you didn't argue paragraph 5 of the loan modification agreement where he had given up all of these things that happened for the benefit that he was getting here? We don't see that in your briefing.
Right, Your Honor. So those were, we rely on the documents for that. And it was it probably should have been in the briefing. But the facts remain, the fact that due to the hybrid nature of the foreclosure and the fact that, you have an action in equity, and the judge pointed this out as well, you have an action in equity with respect to the actual foreclosure of the mortgage, and you have the legal action with respect to I guess call it a breach of contract with respect to the promissory note and the mortgage. We have two separate and distinct issues there. So the fact that the unclean hands argument prevailed and may bar, and that's an operative word, in the fact that it may bar, it doesn't necessarily require that the foreclosure action is completely dismissed. I believe that that's what the trial court was attempting to do, was make that separation, make that distinction between the actual foreclosure of the mortgage, as well as the I guess, and like I said, breach of contract with respect to the promissory note and the mortgage itself.
And this may be place, Judge Lambert and I land in different places, but I'm wondering if the modification agreement was what was set aside. It takes you back to that point in time where, okay, you've got the original mortgage. Why wouldn't the judgment be for 157 instead of 186 or whatever the amounts were?
Because of the attorney's fees provision. The attorney's fees provision within the
but the principal, I mean, they had upped the principal to include all the interest that had accrued up to the time of the loan modification. He sent the modification, but you all submitted a judgment. He signed the judgment, lined through a lot of the other things. But
right, Your Honor. And to be honest, I'm not perfectly sure why the capitalized, because it basically, rough figures, evens out that the capitalized interest on that was as a result of the modification was also given as a final judgment amount. The judgment figures that are in the record detail all of the expenditures, whether it be legal or whether it be taxes and those sorts of things, and as well as interest. And I don't have a great answer for you with respect to why that 30,000 was tacked on if we're still throwing out the modification. However, the facts remain unchanged, that there was a breach of the mortgage and the original promissory note. There was also a breach of the modification agreement, and now, even though that was tossed out due to appellant's affirmative defenses, at the end of the day, we still have a borrower who was in breach of their agreement with the lender. We're not in a position, and quite frankly, not many lenders are in a position to forego payments and interest amounts in order to somehow arise. It's inequitable in order for that to occur, in order for someone to
I understand your bank's in the interest is in the business of interest, not principal. Principal is what was theirs anyway. I get that. I think all the judges up here get that. I think the trial judge got that, and he was invited to sit in equity and do what he thought was right. And he seemed to think you don't get all the interest. You don't get what your business is because you had unclean hands. But now you're coming back in and saying, no, we should get that too. Why didn't you argue against what the findings were?
The findings of the
unclean hands and all the other.
Because the unclean hands defense, so we, as I kind of stated, with respect to the hybrid nature of the foreclosure action, there is the ability to separate the two from a theory perspective. And the fact that even though the affirmative offenses were there, we were still the prevailing party with respect to the excuse me, with respect to the underlying foreclosure.
And how is that not go ahead, Brian.
Let me make sure I'm clear about your separation of actions and equity and actions at law for damages. So is it your view then, let's take it outside the realm of this case, a bank could behave in the most egregious fashion possible, and unclean hands is proven the best proof of unclean hands in the history of Florida jurisprudence, and the judge finds that, but you can come back and say, well, that's just the equitable part of the foreclosure. We still get a judgment for the underlying note and mortgage. Is that your position in the context of what you're arguing?
No, Your Honor.
Then what is it you're saying when you're separating these two? I mean, you seem, I'm hearing, and tell me if I'm wrong, I'm hearing saying, well, even if they found that those unclean hands, equitable estoppel, that's just on the foreclosure part of the suit. That doesn't have anything to do with the fact that the note is owed and we should get a judgment for damages. Is that your position?
Sort of, Your Honor. So the fact that
what part sort of and what part sort of not?
The fact that if we take your hypothetical and let's say we're dealing with a simple loan, we're for a small business loan or something like that, and there isn't a secured aspect of it with respect to real estate or something else like that, and then that loan is then modified. And let's say that there's another expenditure of principal, there's another, a raise in interest rate or lower an interest rate or whatever. And there's a situation where there is an unclean hands affirmative defense that's successfully raised. At the end, that particular defense is maybe, and with this case, it may affect the modification of the I guess the extension of additional principal and that, but we don't have that.
Just to let you know, you're into your rebuttal time.
Thank you, Your Honor. I'll quickly wrap up. So the underlying transaction, the underlying loan transaction is what we're focusing on with respect to separating the hybrid nature of the equity versus legal argument here. And with that, I'll reserve the rest of my time.
Mr. Greenlee?
Yes, Your Honor. I'd like to just, because I didn't have cases handy in my original oral argument, with regard to unclean hands, and this is from the United States Supreme Court. It is Precision Company versus Automotive Company, 324 U.S. 806. They describe unclean hands as a self-imposed ordinance that closes the doors of a court of equity to one tainted with inequitableness or bad faith. So the door closes, right? That's the U.S. Supreme Court. Then we have, for equitable estoppel, Major League Baseball versus Morsani, where the court says where a defendant establishes the effect is that the plaintiff is, quote, absolutely precluded, both at law and in equity, from asserting those rights that might have otherwise existed. So that essentially, again, equitable estoppel was also an affirmative defense. So that obliterates this whole notion that this is a hybrid action and there's legal and then there's equitable. No, if it's equitable estoppel, you can't either in law or in equity recover. And
So
again,
what do you do with Supreme Court case law that talks about the doctrine of unclean hands as not being a rigid formula which trammels the free and just exercise of discretion, but is applied upon considerations that make for the advancement of right and justice?
Well, I would say that the court found that there was unclean hands here. And so I don't think that we can go back and undo that finding, not at this stage in the proceedings.
Correct.
Right. So the judge found that there was unclean hands. And while there may be a little bit of play in the joints, so to speak, in what constitutes unclean hands, we found it here. And
well, I'm not talking about what constitutes. I'm accepting the finding, and but I am challenging the application of the finding. So I see United States Supreme Court case law that talks about things like discretion in finding solutions. And don't talk about it being an absolute bar. And so I go back to what Judge Stargill said at the very beginning of this oral argument.
Okay. Well,
what did he say?
But I would say, Your Honor, this is a one-count complaint, and it brought an action for mortgage foreclosure. There is no, I don't understand the argument that this is a hybrid action. This is a mortgage foreclosure, and we have Bartram, which says mortgage foreclosure is an equitable remedy, right? The only time you would get to the legal portion of it is if there's a deficiency judgment. But first they have to secure the foreclosure, sell the property, and then there has to be some shortcoming. And then, and only then, do you get to the legal aspect. So I don't understand this to be
let me follow up with Judge Stargell said initially, what Judge Nardella just said now, as to the issue of, okay, your trial counsel, the trial counsel for the ward says, basically, Judge, let's come up with something that's equitable here. And so the judge does it, and the judge kind of goes off on, makes this long pronouncement of the findings, and basically is trying to say, the mortgage has been paid, but there's these unclean hands, etc. So I'm putting it all together, and in this stream of consciousness findings, this is what I think is the fair result for both sides in this case. Here's my judgment. Have a nice day. Boy, y'all, this isn't your typical foreclosure that I'm seeing as a judge, but that's my job, and here we go. Why do we find then that the judge abused his discretion in coming up with an equitable remedy based upon the dog hair on both sides, for lack of a better legal term?
Well, I would say this, Your Honor. Mr. Ward was trying to save his house.
Well, we all know that. Everybody in foreclosure wants to save their house.
He wasn't trying to shave off a little bit of interest, and it's profoundly inequitable to take his house away from him when the lender lies to him, breaches its own forbearance agreement, the loan changes hands, and then the lender says, well, we're not going to abide by this. We don't have to abide by this.
But in essence, Mr. Greenlee, your counsel asked for equity. The judge gave him what he thought was equity. Your client, I don't know that they lived in the house. They might still be living in the house, but for some time since 2008, all of this has been out there. I don't know what they've done with what otherwise would have been the mortgage payments, but the judge made a decision and said, this is equitable. You don't get to keep your house, but they're not going to get a judgment lien against you for all of that interest that you would have earned. Thank you. Have a good day. And then you appealed it.
Right.
Well, we want it. And now they're asking, oh, well, we also want the interest.
Well, it's for one thing, it's conceptually incoherent to say that they have in an action in equity, which this is not a hybrid action. This is a mortgage foreclosure, one count mortgage foreclosure complaint. And it's conceptually bizarre to say you've carried your affirmative defenses of unclean hands and equitable estoppel, and yet you let the lender prevail on the case. And that's our argument in a nutshell, and we think it's a good one. So
you would have us do what? Step back in and implement the original mortgage, or set up tell the court to set up a payment plan, or just say, never mind, the mortgage goes away, because you had a problem with the note and you wouldn't accept a payment or two back then, and that created unclean hands because a judge said so. Here's your house. Have a good day.
No, Your Honor, we wouldn't. That's not what we're asking for. We're asking for the reversal of the trial court, the entry of the granting of an involuntary dismissal on remand because they failed to carry their burden. And one more thing on that, Your Honor.
Okay, but where does that leave it then? There's still a mortgage on the house.
Where it should leave it is you should put Mr. Ward back in the position that he would have been in, but for the breach of the forbearance agreement. So if you could reinstate those terms, then that would be equitable.
Didn't Mr. Ward have legal rights back then before he filed his loan modification agreement? If he wanted to go out and say, I got a forbearance agreement here, you should accept my payment and enforce his forbearance agreement instead of signing a loan modification?
Well, they already told him that they were foreclosing on his house. So they lied to him about that, by the way. They said, we can't accept this payment because we're foreclosing on your house. So if that's equitable, then, and the court wants to find that that's equitable, I can't do anything about it, but it's not. He wants to save his house. He did everything in his power to save his house through the forbearance agreement. He only entered into the loan modification agreement because they told him he had to, and then he couldn't afford it because they tacked on $30,000. So that's not fair, Your Honor.
Well, but they knew that they were tacking that, using your term, tacking that on. That was the terms of the modification agreement, and he agreed to it because, for right or wrong, that's what he thought he needed to do, right?
Well, it was either that or they take his house and he gets nothing at all. I mean,
or he could just say, I'm not going to do that. Go ahead and sue me. I got my defenses and I'll go forward and I'll see if a judge rules in my favor. Right?
Well, that's what ultimately happened, and the judge did rule in his favor.
Okay, go ahead. That's fine.
All right, your time is expired. Mr. Hayes, I'll give you the 2 minutes that you wanted to reserve.
Thank you very much, Your Honor. There's a couple of different aspects of this with respect to the I guess the overall or the underlying issue in this whole thing. Opposing counsel has stated that Mr. Ward was doing everything in his ability to keep his home, with the exception of paying his original mortgage. That's why we're here, and that's why the forbearance agreement was.
Counsel, I don't think that's lost on us. Can you address the attorney's fees? Because I don't see that issue addressed in your briefing. Why is Mr. Greenlee not right that you guys didn't put in the evidence you need for confidential evidence finding for not only the amount that work that was done, but the reasonableness of that work?
Right. So said capital holds that either we require attorney testimony or detailed business records that encapsulate and describe what.
Right. So you had Mr. Cummings, right? He was your witness.
Correct.
I've reviewed his testimony. Is there any exhibit that I'm missing that was entered that would support the $50,000 in attorney's fees or legal costs that were broken down to some portion of attorney's fees? Because Mr. Cummings couldn't even tell us the date these were incurred.
Right. We would argue that the admitted exhibits 12 and plaintiffs exhibits 12 and 13, which are the judgment figures and the detailed payment history of the loan, provided substantial competent evidence with respect to the incurrence of attorney's fees over this foreclosure litigation that lasted, over the course of time. That from a default date of 2013, this case was filed 2018. So with respect to I guess 2018, it's 2024. So with respect to 5 years of litigation over this particular thing, we had we had a motion to dismiss that was appealed and tossed back. We had a full trial that was continued for 6 months. Okay,
so it's your position that if I review 12 and 13, exhibits 12 and 13, that will meet the requirements of Roe?
They do not detail the lodestar requirements of the attorney's fees provisions, but they do provide enough color that gives a reasonable observer the fact that, okay, the $50,000 that was incurred and the $50,000 in legal fees that we were asking for were reasonable under the circumstances of the litigation.
Or at least half reasonable, which is what the judge decided.
Right, Your Honor. That's so, and that's the arbitrary slashing of that is it's we're not so arguing with respect to the attorney's fees. I understand said capital. I understand that holding, and I understand that the lodestar amounts and then the qualifications and of that weren't precisely met. We're more so arguing with respect to the interest and the additional costs and fees that have been kind of accrued over the basis of the life of this litigation.
So did I hear you correct? You're not challenging the diminution to 25,000. Mr. Greenlee is saying you shouldn't get any, so you're not challenging that.
We're challenging the diminution of it. However, in my response was more towards Judge Nardella's question with respect to whether, if she looked at plaintiffs 12 and 13, whether those would meet the requirements of Roe and said capital.
Because they don't, right?
Well, thank you, gentlemen, for a nostalgic walk down foreclosure crisis lane, and one of our final cases, hopefully, that deals with some of these issues. But thank you all for illuminating the issues for us. And with that, unless either of my other colleagues have anything else, we will stand adjourned.
Nope.
Thank you, Your Honor. Have a great day.
Thank you, Your Honor.